Hello, my name is Brett Wasley. I'm a supervising deputy district attorney here at the Sacramento County District Attorney's Office. Uh, Welcome to a brief presentation on a background and implementation of Proposition 36, which was recently enacted by the voters in the state of California. This presentation will give a brief overview of the statute and then talk about the drug part of the statute, then the theft part of the statute, as well as some related theft laws that the California legislature passed, which will take effect in January of 2025. Proposition 36, the Homelessness, Drug Addiction, and Theft Reduction Act, was passed overwhelmingly by the voters in the state of California. The slide here says 70%, the numbers only went up. In discussing the purpose behind this law, it talks about the downstream effects from Prop 47's passage in 2014 and the increased drug addiction rates as well as homelessness rates and theft-related offenses, which are all intertwined. The purpose of this act is to address and remedy this problem. Proposition 36 creates two new wobbler offenses. Wobblers are offenses that could be charged as either misdemeanors or felonies at the outset. The first one deals with hard drug possession, and it's Health and Safety Code section 11395. It says simple possession of a hard drug with two prior drug-related convictions can be charged under this section. Hard drugs are defined as fentanyl, heroin, cocaine, crack cocaine or cocaine base, methamphetamine, PCP, and their analogs. In order to be charged under this section, you must have qualifying priors. Eligible qualifying priors are convictions for Health and Safety Code section 11350, 11351, 11351.5, 11352, 11353, 11353.5, .7, 11370.1, 11377, 11378, 11379, 79.5, .6, 11380, and finally 11395. These all deal with possession and trafficking of hard drugs. For the theft-related provision, it added Penal Code Section 666.1, petty theft or shoplifting with two prior theft-related convictions. Qualifying priors under this include convictions for 211, 215, elder theft, 368, obviously 459, shoplifting convictions under 459.5, petty theft, grand theft, 47H, 488, and 490.2. Let's discuss the hard drug provisions under Prop 36. This is aimed at, as it says, habitual drug offenders. We mentioned the qualifying priors. This only applies to hard drug possession, so possession of marijuana or LSD or mushrooms, psilocybin, they do not qualify. It's aimed at hard drugs, as mentioned. In order to be charged with Health and Safety Code Section 11395, you must have at least two prior convictions. A first conviction under this statute is punishable by a wobbler, again, like I said, either a misdemeanor or a felony, and you can be punished either under a misdemeanor sentence or in county jail prison pursuant to 1170H of the Penal Code. A second or any subsequent convictions under 11395, meaning you have at least three prior convictions, it's still a wobbler, and it's punishable in county jail prison or state prison. The drafters of this proposition did not include a washout period. That means the age of the prior conviction does not matter. Now, DA's offices will have different internal guidelines on how they're going to apply and charge this statute. It's important that you talk to your local DA's office to see what their internal filing guidelines are on the matter. The purpose behind the drug portion of this is not to send drug users or habitual drug addicts to prison. And that's why the statute specifically allows judges the full gamut from they can make it a misdemeanor at the outset, and if it's your second conviction, all the way up to state prison. That said, to do any jail time or prison time on this, the offender must refuse a treatment program or fail out of it or be deemed not eligible or suitable. Now, as mentioned, the purpose of the statute is treatment. So treatment must be at the request of the defendant. It requires a guilty or no contest plea, unlike mental health diversion. The defendant must admit prior drug convictions and all the other non-drug offenses on the docket. They must waive time for judgment and sentencing, and then the court orders 2 evaluations, one from a drug addiction expert and the other assessing the defendant's eligibility under various insurance programs, Medi-Cal, Medicare, or other programs. The statute doesn't offer that many concrete details onto the length of the treatment. I imagine those will be worked out locally through probation and the local courts. It does require regular progress reports or hearings. Upon successful completion, the charges will be dismissed and wiped from the record. If there's an unsatisfactory performance, new conviction for the crime after starting treatment is an example of an unsatisfactory performance. Failing out of the program through failed drug tests, et cetera, et cetera. The defendant is entitled to a hearing to determine whether the performance was unsatisfactory, and the statute specifically says, like, for example, if you can commit a new crime after you start treatment, that is a possibility to get you out of the program. Upon failure, again, the court has full discretion in sentencing. That means that they look at the suspect's entire record, their performance in the program, et cetera, and they craft a sentence that the judge feels is appropriate. The statute clearly says that there are no conduct credits or Penal Code Section 4019 credits for times that the defendants spend in residential rehab, meaning they won't get conduct credits. They just get day-for-day credits. Proposition 36 also amended Health and Safety Code Section 11370.1, and it added fentanyl to that statute. This statute is punished by 2, 3, 4 years in state prison. It added Health and Safety Code Section 11370.4 enhancement, which is a weight enhancement as it pertains to fentanyl. So if you have over an ounce, it's a 3-year enhancement. Over 100 grams, 5 years. And it goes all the way up to over 80 kilograms, gives you a 25-year enhancement. These are to be served in state prison. It added Penal Code Section 12022, Subdivision C, armed with a firearm in the commission of a drug offense. This is also punished by 3, 4, or 5 years in the state prison. Another area it added was Penal Code Section 12022.7, Subdivision F, Subdivision 2, infliction of GBI in the commission of a drug offense. Any person who sells, furnishes, administers, or gives away a controlled substance is deemed to have personally inflicted great bodily injury if the buyer suffers substantial physical injury from the substance. This overrules a case and clarifies the intent that you can be charged with a great bodily injury enhancement, making this a violent felony, if the buyer suffers a substantial physical injury from ingesting the substance. Alexandra's Law, this is important. Drug advisory for convicted hard drug offenders, Health and Safety Code Section 11369. This is akin to the Watson admonishment that is given to drunken driving offenders, and it says, "You are hereby advised that it is extremely dangerous and deadly to human life to illicitly manufacture, distribute, sell, furnish, administer, or give away any drugs in any form, including real or counterfeit drugs or pills. You can kill someone by engaging in such conduct. all drugs and counterfeit pills are dangerous to human life. These substances alone, or mixed, kill human beings in very small doses. If you illicitly manufacture, distribute, sell, furnish, administer, or give away any real or counterfeit drugs or pills, and that conduct results in the death of a human being, you could be charged with homicide, up to and including the crime of murder, within the meaning of Section 187 of the Penal Code. This is known as Alexandra's Law. Like I said, it's akin to the Watson Admonishment, and it's putting drug dealers on notice that if you deal drugs and the buyer overdoses and dies, you can and will be charged with murder. Now, different DA's offices will handle this differently. In Sacramento, we are going to work with our law enforcement partners to work on an advisement to advise people who are arrested for this crime, for drug dealing, to be read this, preferably on body cam, at least documented in a report, because it is putting them on notice. Health and Safety Code Section 11369 requires the judges to do it at sentencing and read it, but in Sacramento, we think the better practice is to also ask our law enforcement partners to read a version of this to suspects, so they are put on notice. Now we will segue to the theft portion of Prop 36. As I mentioned, it added Penal Code Section 666.1. Qualifying priors for these are theft offenses, and that can be very broadly construed as theft is defined in the Penal Code. Common ones, as mentioned, are robbery, carjacking, elder theft, burglary, shoplifting, petty theft, grand theft, car theft, identity theft under 530.5, embezzlement. Out-of-state felony convictions may qualify, but it has to be felony convictions. What this means for our law enforcement partners is when you arrest somebody for shoplifting, it is important, in fact essential, for you to run the RAPs, state and local RAP, so we can determine whether they qualify under this new statute. Now, the first conviction under Penal Code Section 666.1, meaning you have two qualifying priors, so this will be your third theft-related conviction. It's a wobbler, punished in county jail or in county jail prison. The second and subsequent convictions under this, meaning you have at least 3 prior convictions, it's still a wobbler, punishable in county jail, or this time in state prison is an option. And these are 16-2-3 offenses, meaning 16 months up to 3 years. Like the fentanyl portion or the drug portion, there is no washout period. The age of the prior conviction doesn't matter. Now, DA's offices might have different internal guidelines with how they charge this, and that's important for you to check with the district attorney's office to find out their internal guidelines. This statute also made it easier to aggregate the property value under Penal Code Section 490.3. It applies to any act of theft or shoplifting, value of the property, or stolen merchandise. It can be aggregated into a single account or charged to determine the degree of the theft. It basically makes it easier to get to over the $950 threshold for grand theft. It can be different victims, different days, no requirement that it be part of the same common plan or scheme. This is again aimed at repeat theft offenders, and it allows the charging or aggregating a value to a 487 to make it a felony. The statute discusses pretrial release of defendants. In Sacramento, this won't change much because this already happens, but it requires a judicial officer to determine a risk to public safety and likelihood of return to court. As mentioned, this doesn't really change. This is how it operates in Sacramento County, but this is now mandated statewide. So depending on the county and how your pretrial release program works, this requires a judicial officer to make that determination based on public safety and the likelihood of the charged defendant to return to court. statute also added Penal Code Section 12022.6, excessive taking or damage enhancements. It applies to a person who takes or damages or destroys any property in the commission or attempted commission of a felony, or commits a felony violation of Penal Code Section 496. So this applies to theft, this applies to vandalism or receiving stolen property, and it adds time if the damage is over $50,000, 1 year, over $200,000, 2 years, over $1 million, 3 years, over $3 million, 4 years. Every additional increment of $3 million is another year in county jail, prison, or state prison. Prop 36 also added Penal Code Section 12022.65, acting in concert enhancement. Any person who acts in concert with two or more persons to take, attempt to take, or destroy any property in the commission or attempted commission of a felony, is eligible for this enhancement, and it adds 1, 2, or 3 years consecutive to the underlying offense. So this is directly applicable to looting situations where people act in concert to destroy and or steal property from stores. In addition to Prop 36, there were a few theft-related law enactments by the legislature for 2025. Now, it's important to know Prop 36 goes into effect at the latest by December 18th of 2024. These new theft-related laws don't start until 2025. A big one is it allows for arrest without a warrant for shoplifting. It amended Penal Code Section 836. Another one is a 2-year probation for shoplifting under Penal Code Section 1203G. It changed or added forcible entry into a car to commit a theft. Enhancements for the sale of stolen goods under Penal Code Section 12022.10. Also, possession of property through theft from a car, 496.5. There was also a restraining order for retail thefts. Let's discuss a few of these. Arrest for shoplifting without a warrant. Now an officer can arrest a shoplifter if officer has probable cause to believe the person shoplifted, the arrest is made without undue delay, and any of the following: a sworn statement from a person who witnessed the theft, the officer observes a video of the suspect committing the theft, the suspect possesses a quantity of goods inconsistent with personal use and the goods bear security devices that would normally have been removed, or the suspect confesses to the crime. Now, obviously, the big change here is it allows a police officer to maybe just view surveillance video sent by a retail establishment capturing the theft on video without talking to a loss prevention officer. Also, the scenario where you come upon a suspect who's in possession of a bunch of retail goods with the tags on them. If you have PC to believe that person shoplifted, and you make that arrest without undue delay, this statute allows you to arrest a person. Obviously, if the person confesses to the crime of shoplifting, you can also arrest under that scenario. So the purpose of this was to make it easier to arrest shoplifters. Retail theft restraining orders. Penal Code Section 490.8 permits a court to issue a 2-year restraining order to prevent a defendant from returning to a premises of retail establishment. It applies to shoplifting or any theft from a retail establishment or vandalism or organized retail theft. So that permits the court to issue a 2-year restraining order under 490.8. Penal Code Section 490.8, under limited circumstances, also permits the DA or prosecuting attorney to issue a restraining order if that person has been cited 2 or more times for any of the above related offenses at the same establishment. If the court holds a hearing after notice to the respondent and with entitlement to a lawyer, the burden is on the petitioner, meaning the prosecuting agency, to establish by a preponderance that the person, and the court finds substantial likelihood the person will return to the retail establishment. This too can be up to 2 years. That wraps up Proposition 36, as well as a few theft-related statutes coming into play in 2025.